Welcome back to The Pulse. And I told you earlier about our conversation today. We're continuing the conversation on our Profit and Progress show, and we're looking at Ghana's commercial court system. The court has jurisdiction in all commercial claims, including any claim relating to the formation or governance of a business or commercial organization, the winding up or bankruptcy of a commercial organization or a business. The court over the years has been dealing with disputes involving commercial arbitration and other settlement awards, intellectual property rights, including patents, copyrights, commercial frauds, tax matters, and insurance cases. One distinctive feature, however, of the commercial court is the use of mediation and other alternative dispute resolution mechanisms. And so we want to share your views with us on our social media platforms. Send us your questions to the WhatsApp line, and we would read them and find answers. Because joining me in the studio for the discussion actually is Nana Osei Bonsu, who is CEO of Private Enterprise Federation. And joining me on phone also will be Justice Gertrude Tokono from the Judicial Service. And on phone is also lawyer Clara Biri Kaseti from the Institute of Economic Affairs. Good afternoon to you.
Good afternoon.
Mr. Bonsu, good to see you.
A pleasure to see you again.
We know about the court, which deals with commercial issues, but just want you to throw more light on what exactly the commercial court is mandated to do.
You know, there's a whole lot of cases along the value chain, as I said, in the court system. So what the private sector had done, and under the previous private sector development strategy under President Kufuor, commercial courts were initiated to handle cases of not commercial value between private sector businesses or business-related issues. Litigation that, as you said, patent right or infringement on somebody's contract enforcement or other ways. So the commercial courts were entitled or mandated to sift through all the cases that come through the judicial system and handle those with a commercial value between private sector players or government taxes and others. Over the years, they scored more than anybody else in this judicial system, and it was efficiently and effectively being utilized to adjudicate cases between private sector players. And one of the mechanisms in the system was the use of the resolution, pretrial resolution or agreement between partners, because it resulted in speedy or expedited handling of issues or cases, because you don't want private sector businesses to be held up for adjudication 5, 7, 6, 8 years like the previous things that were happening. Using that mechanism allowed the players to come together, see what the merits of the discussions, and with the presence of an arbitrator or a judge, the case was resolved to the relief of everybody else. So those were some of the high points. But sometimes success is your own worst enemy, and the commercial courts were doing fantastic, where the pretrial hearing or adjudication resolution was resulting in cases of almost about 60–70% of the cases were being resolved within few months after the application, unlike the others that were dragging through the court system for years. But then, because of the efficiency, I think the judicial, whatever the scenario was, decided to move some of the judges to bring that efficiency to the other sectors of the judicial system. So the system declined gradually to a point where only 20% of cases are use the arbitration system, and cases are now backlogged, and they're long processes to resolve issues. But for private sector, it's like they say in the judicial circles: justice delayed is justice denied.
Exactly.
Anytime there's a delay, it costs us money.
Yes.
And we know that at the end of the rainbow, there's going to be a resolution. There's going to be a judgment. So why do we wait 5–7 years for the judgment? Why can't we get a judgment and move on to other things? So what we're looking at, as I said, this business enabling environment reform started under the PSDS1 and then flowed through to 2010, where things didn't work out too well. So DFI, the Department for International Development, supported the government of Ghana to try and upgrade certain state institutions, GRA, registered generals, commercial court system, the paperless, and a whole lot of them. But then when the program started 2015, getting to an end 2020, we see that there are a lot of reforms that had been undertaken, and we wanted to make sure that the private sector and the public are aware of what is going on and push the envelope a little bit so we can have a little more mileage on the case, on the issues. So so far we've done the paperless, we've done the GRA, we've done the registered generals. We're now on commercial court system.
Commercial court system.
And we want to see how they've done a lot of things. But to me, or to the private sector, it's not enough. And they themselves recognize the deficiency they have within their system.
Exactly.
And how do we speed up these reforms? How do we bring the private sector from outside to realize that, yes, these are things we need, and to push for that to happen before the program gets to an end.
Exactly. And I'm going to look at some of the reforms that will be undertaking, but of course we need to establish the challenges facing the commercial court to be able to get to the reforms. One key thing is the inadequate judges which is faced by the commercial court. How dangerous is this situation?
Well, you want a resolution of a case. You don't want to bring anybody from the woodwork who doesn't understand the merits of the case and then mess up with the decision. So you need judges or people who have been trained to be able to, settle the dispute. So, but we have limited resources and we have limited judges. And I don't think you can push for influencing the employment or the appointment of judges en masse. So what we're looking at is how do we then remove the judges from the arbitration system and bring other people, maybe lawyers or people of repute, who can be trained to settle the disputes, because the judges are not enough. And to move them to settle, and once a judge is involved in arbitration, if it doesn't work, he cannot go and sit on the case. So you have to remove one person outside anyway. So we look at how do we create a pool of people and train them with the requisite expertise to be able to handle these disputes.
But there's also one key area, which is the rules that govern the
commercial court system.
Yes,
I think we talk about Order 58.
Exactly, Order 58. I know there's also Order 54, which deals with civil procedure. That also has aspect of it that deal with commercial issue. But mostly is the one that deals with the commercial court system, which is the Order 58. Its implementation has been very problematic. I mean, if you follow all the trends, you realize that, I mean, it's just not being implemented as it ought to be. What is the challenge?
Well, that's why I said beginning, the commercial court system is its own worst enemy. The Order 58, or the arbitration under the commercial court, was mandatory at the time. So whether you like it or not, you got to subject yourself to. And once people, the cases were resolved, and then come to the enforcement of judgment. The people who lost normally would now say, hey, wait a minute, I don't like this, and I was forced into it. I wouldn't have done it anyway. So they join their lawyers to go to court and bring the case back into the system, which shouldn't have been the case. Now that I think the Users Committee, of which the Private Enterprise Federation has a representative, are bringing to the fore that, look, it's going to be voluntary. And let's remove it from the mandatory requirement and make it voluntary, that partners or people who bring the cases to court would voluntarily subject themselves to the arbitration. If that happens, then a lot more people will participate, and the relief will not flow back into the court system and clog the system as it's going now. So you're right that it's been an issue, and if we continue to look at it from the mandatory type point of view, then definitely it's going to derail the expedited sessions, the expedited processes that we're looking for the commercial courts to undertake.
And more importantly, also has been the issue with the e-system, because I mean everyone is going electronic, and I was particularly happy when the judicial system said they were going that way. But I mean, after so many years, it just looks like the implementation or even the staff getting acquainted to the e-system has been a problem. Why are we here?
You know, like everything else, innovation is always new, and people sometimes they don't want to move from their comfort zone. And the judiciary system is no exception to everybody else like you and I. So the training had not gone on gone as fast as we wanted, and the partners or the people involved should be trained in a way that the capacity that they need can be enhanced for them to settle the use the e-application system.
Okay.
Now, doing so is also an issue, because if you have e-application, there are no lights, obviously you cannot undertake that. And the absence of the internet access to certain areas, that also precludes the use of that in certain areas. So there are, when we talk about the deficiencies in the challenges in the system, we also talk about resources available to the court system to be able to do. We have to find ways that the court can replenish the resource. It's not only going to be on the back of what budgetary allocations are made to them. So we have to look at the whole ball of wax as to how do we move the judiciary to the 21st century to adjudicate cases as fast as possible and make sure that the reliefs are set up to the partners.
That's why I think the ADR and the mediation system is very important. I'll get to that and get details of that. But Justice Gertrude Tokuno is from the Judicial Service, and she joins us. She handles most of these cases that comes to the Commercial Court. Good afternoon to you, Madam. Thanks for your time on the Pulse.
Hello, good afternoon.
Particularly, the worry has been the implementation of the Commercial Court Rule, Order 58. We know that it's not been functional, especially at the district courts. What has been the obstacle hindering the implementation of this rule, knowing how important this rule is if the Commercial Court is supposed to function properly?
Thank you for your question. I think I have to clarify something. There are 5 levels of courts in Ghana. The district court use rule numbered CI, or Constitutional Instrument CI 59. Then the Circuit Court and the High Court use CI 47. And Order 58 is within CI 47. So the district courts do not use the Order 58 rules because it's not part of their rules.
Okay.
That's an important distinction. Then when it comes to your question that we haven't had a very effective implementation of Order 58 rules, meaning that we haven't had a very effective implementation of the ADR rules under the Commercial Court rules. Why has this been the situation? My response would be that there are several reasons.
Okay.
One of them, don't forget that before CI 47 was implemented, and it was implemented in 2005, we had had about a century of pure litigation in this country.
Yeah.
Where the rules of court recognized ADR under the Court Act and encouraged ADR, but we didn't mainstream it into the litigation or the dispute resolution system. So many lawyers and many litigants felt more comfortable with litigation.
Okay.
Then the next thing is that for a pretrial settlement conference, which is the ADR system, that's the official name for it, for a pretrial settlement conference to be successful, the parties have to agree terms of settlement. Now and sign it. Now, terms of settlement can be agreed and signed, especially for corporate bodies, by people who have the authority to enter into those terms of settlement. Are you there?
Yes, you're still on air.
For people who have the authority to. So if you have a lawyer coming with somebody, a middle-level person who doesn't have the final authority to agree, you have back and forth, and you cannot have a very successful mediation conference when the decision maker is not part of the conference.
Exactly.
So so we have situations where many corporate bodies were leaving this role to their external solicitors or middle-level managers who represented the body in court. And this is one of the reasons why there's been a hampering. So I've given you two reasons. One of them is the culture change from litigation to settlement. The second one is the lack of ownership by those who ought to have enjoyed the process rather than imagine that they are fine without it. And I say they ought to have enjoyed it because if you settle a case out of court and file terms of settlement, it's unappealable. It's deemed to be a contract, and no party can appeal against it. So you have you could actually be saved as much as about 5 years in court if you settle your matter at the pre-trial conference, which is the thinking, the public policy thinking that went into the Order 58 rule.
Justice Dokuno, the EJustice system, you will agree that is a very important part of the judicial system. And when it was introduced, I quite remember some time ago when the judicial system wanted to go electronic, we were all happy about it. What can you say about the EJustice system as far as the training of judicial service staff is concerned?
It is marching forward so strongly. I think you really need to visit us and see how we are working diligently and assiduously to ensure that it's properly implemented. Don't forget that this is a total process change. Instead of finding people manually, now we need to be serving them by SMS or email. These are we require laws passed in Parliament. So the constitutional instrument for that is currently before Parliament. It's not just about training staff, but we also have infrastructure, we have softwares, we have to have institutionalized arrangements, which we are working on. So there's an oversight committee for ensuring that this e-justice works very well. We started implementing it. And the oversight committee is chaired by a Supreme Court judge. We have all sorts of technical people on that oversight committee. We have a technical working group, and every 2 weeks they meet. It's a very robust system. And God willing, I mean, we're talking about the whole nation changing. God willing, sooner than later, you will see everything perfectly, but we have started it. And it's working.
But what has been your biggest challenge in instituting this?
I think the biggest challenge has been in the sheer volume of material we have to work with. For instance, when a party comes to file a suit, an e-docket, an electronic docket is created. Now that electronic docket has to have special features, has to have special records for the litigants. And then we have in the court e-justice system, there's a module for the court clerk, the court recorder, the judge, the lawyers, a module for parties. There's even a module for the Chief Justice, a module for registrars, and we have to make sure that there's proper synchronization. So we are testing. Right now we are testing, we are applying, but the sheer volume is sometimes one of the major challenges we have. Because, for instance, processes are filed. Let's say 40 processes are filed in the space of 20 minutes. And the docket clerks have to scan all of this and ensure that they are properly placed in the e-docket for the judge's model to see, for the registrar's model to see, blah, blah, blah. And these are some of the challenges.
Well, we'll be monitoring. Justice Gertrude Tokuno, many thanks for your time. We'll be monitoring the Judicial Service and the Commercial Court to see how things pan out as we talk of reforming the place. So let's talk about some of the reforms, because you heard Justice Tokuno there enumerating some of the challenges they're facing there. So reforming the Commercial Court is actually in the right place. What are some of the reforms you're seeking to see at the Commercial Court?
What we want to see speedy announcement of judgments.
Okay.
We have had cases where the private sector had heard that the case is final, there's a judgment passed, but the judgment is not written for a while. And you know, when the judgment is withheld for a period, it allows the person who lost to go home and see how to address the attachment of his or her property.
Okay.
So once the judgment is written and the lawyers receive it, that's when you can enforce the judgment outside. By that time, whoever lost the case might have sold out all the assets under their name, and then you left out holding the bag. So what we look for in one of the meetings with the hierarchy of the judicial system, there was a consensus that there must be an electronic notification of judgment. So when the judge reads the judgment in court, it becomes an automatic authority for whoever needs to do whatever they need to do to take that action, to take the immediate action based upon that judgment.
Okay.
Unless, instead of going home to wait for months, weeks or months for the judge to write the official. But they're also, in the system, there are also constraining factors, because before you file for appeal or these things, there are a lot of constraining structures. And those are the ones that also need to be looked at to streamline that processes, because once you do one side and you leave the other side, then it becomes a roadblock at the end of the rainbow, and you cannot make an effective means of what processes you're looking for. So one of the points is the speedy judgment to be declared and authorized for people, whether it's e-platform, and also the other part is the notification by bailiffs. You know, previously bailiffs have to travel and hand over. If you don't want to be seen, maybe you go under the bed, and you know, they're not home. Nana Osei Bonsu says he's not home even though he's under the bed. But now we go in electronically, and they can notify by electronics, because the cost of bailiff traveling back and forth is also adds to the burden of financial resources needed. By,
Okay, that would be good to see cases being dealt with speedily, and that also will mean that the ADR system and the mediation system will be strengthened, because these are areas that do not go strictly with the litigation process, and so you can just deal with it in a week, in 2 weeks, and you're done. So it looks, I think that strengthening these two areas, how do you seek to do that?
Well, you see, let me even step back on the case management. Pretty hearing that the leadership mentioned. We're going to court. The judge assembles all the partners, the private sector players and their lawyers. And they said, okay, what are we going to do, timelines and all. Then we agree. Sometimes the cases are, obviously postponed for flimsy excuses by different parties and all. Whilst the judge almost previously did not have that much authority to order.
Yeah.
Now we are here. If we have a pretrial hearing and we all agree this is going to last 6 months, and then whoever doesn't follow the management of the case through the system should be penalized.
Yeah.
And those are the kind of things that we want to see in the system, because no matter how long it stays in court, there's going to be a settlement one day. That settlement should not be prolonged unduly based upon somebody's excuses and all. So we want to see it faster, expedited in a way that there will be absolute resolution, whether I have to pay or not. That is not the issue. That whether there's a judicial process fair and fair to everybody, that definitely needs to be looked at from that perspective.
Thank you very much, Nana Osei Bonsu. I'm extremely grateful for your time. He's CEO, Private Enterprise Federation, and as you may know, Profits and Progress is a partnership between Multimedia Group, IEA, ISER, and PEF, and it's sponsored by the Department for International Development under the UK government. Thank you so much for your time on the Pulse.